Hello and welcome to this one-hour forum featuring candidates vying for 2 seats on Ohio's highest court. I'm Karen Kassler, Chief of the Ohio Public Radio and Television State House News Bureau.
And I'm Curtis Jackson, anchor at Spectrum News. Thanks for joining us. This Ohio Supreme Court Judicial Candidates Forum is presented by the Ohio Debate Commission, a coalition of news organizations, universities, and civic groups that encourage respectful civic dialogue.
Our forum is virtual, with our candidates joining us via the web. We have 4 candidates in races for 2 seats on the Supreme Court of Ohio. Incumbent Justice of the Supreme Court of Ohio, Sharon L. Kennedy, is challenged by Judge John P. O'Donnell of the Cuyahoga County Court of Common Pleas. And incumbent Justice Judy French of the Supreme Court of Ohio faces challenger Judge Jennifer Bruner of the Ohio 10th District Court of Appeals.
The Ohio Debate Commission drafted tonight's format and rules. Candidates agreed to both. Our forum will run 60 minutes. Each candidate will make brief opening statements of 30 seconds, and then we'll begin with our questions. Neither the candidates nor their campaigns have seen the questions in advance. Candidates will have up to 90 seconds to respond to questions, and any mention of other candidates and responses is not allowed. Candidates will then have 60 seconds each to make closing statements.
We should note that because judicial candidates cannot discuss matters they might have to rule on, the Ohio Debate Commission formed an advisory panel, including the Honorable Ronald Adrien, Justice Yvette McGee Brown, and Justice Judith Lanzinger, to help formulate questions that do not call for candidates to violate the state's judicial canons. No responses by the candidates should be interpreted as taking a position that would affect the outcome or impair the fairness of a matter known to be pending or impending in any court in Ohio or the United States. A coin toss conducted with the candidates and their campaigns earlier determined the order of opening and closing statements and questions. Let's welcome our candidates now. Sharon L. Kennedy, Justice on the Supreme Court of Ohio, faces challenger John P. O'Donnell, Judge in the Cuyahoga County Court of Common Pleas. And Judy French, Justice on the Supreme Court of Ohio, faces challenger Jennifer Bruner, Judge on Ohio's 10th District Court of Appeals.
Let's get started. Justice Sharon Kennedy, you have 30 seconds for your opening statement.
Well, good evening, and thank you for the opportunity to participate. My name is Sharon Kennedy, and I am the 9th woman to serve at the Supreme Court of Ohio. I bring 34 years of diverse service to the court, serving as a police officer, a trial lawyer, a judicial trial court judge, and now a justice. I also bring 34 years of service in community collaboration, solving community partners and problems, one family at a time. Thank you.
Judge John O'Donnell, you now have 30 seconds for your opening statement.
Every day I am grateful to be married to Tessa, and I am proud to be the father of Fiona, Kathleen, Owen, James, and Sean. Now, of course, as a judge, I could never preside over a case directly involving my family. But I want Ohioans to know that when I deliver justice on the Supreme Court, I will do it just as if it directly affected my family, because I know it does yours.
Thank you, Judge O'Donnell. Justice French, you have 30 seconds for your opening comment.
Hello, I'm Judy French, and for nearly 8 years now, I've had the privilege of serving as a justice on the Ohio Supreme Court. It wasn't a job I thought possible growing up in the small town of Sebring in Mahoning County, but it's those small town values that have helped me most: honesty, integrity, hard work, and service to others. As a justice and as someone who loves Ohio, I'm grateful for this opportunity to tell you more about the Supreme Court and the important work we do.
And now, Judge Bruner, your opening remarks. You have 30 seconds.
Thank you. Thanks to the Ohio Debate Commission for putting this together. I'm Judge Jennifer Bruner, a judge of the Ohio 10th District Court of Appeals located in Franklin County. In my candidacy for the Ohio Supreme Court, I bring experience as Ohio's first female Secretary of State, serving from 2007 to 2011, and almost 5 years as a trial court judge in the Franklin County Common Pleas Court, 17 years of private practice experience, a mother, a wife, and a grandmother, and a daughter, and a proud person who's lived in Ohio all my life.
Judge Bruner, thank you. We will now begin with the first question, which goes to Justice Kennedy. Justice Kennedy, what is the role of a judge, and how do your personal perspectives inform the rulings you make as a judge? And why did you decide to become a judge?
Well, thank you for the question. I decided to become a judge because I could see a greater role in my perspective of the law, to apply the law fairly and equitably to all citizens, but also to help build collaborative systems to address people's needs. As a trial court judge and facing economic downturn, I had the opportunity to partner with Jobs and Family Services and others, trying to help those who found themselves unemployed find a pathway to gainful employment and earning a livable wage, including those who were formerly incarcerated. But it's more than that. You know, the Constitution and the statutes inform the role of a judge and set our limitations in being separate but co-equal branches. But we're much more than that as we stretch to help others in the system. But also, I believe that our role as judges is to serve as independent bodies, to interpret the law as it's written, not rewrite it or legislate from the bench. Does not mean that we abdicate our role to the General Assembly. As a justice for the last 8 years, I've taken the opportunity to apply the law as it's written. But at times when the General Assembly has gone beyond the constitutional limits, I've been part of a majority to strike down unconstitutional laws, to support home rule and other decisions, and to really write and support public access to public records. Thank you.
And thank you, Your Honor. Next, same question to you, Judge O'Donnell. What is the role of a judge, and how do your personal perspectives inform the rulings you make as a judge, and why did you decide to become a judge?
The role of a judge was enunciated by Chief Justice John Marshall in 1803, the year of Ohio's founding, when he said it is emphatically the province of the judicial department to say what the law is, thereby establishing the doctrine of judicial review, which has survived as really the cornerstone of the judicial branch, which is the independent branch of government. So I see the role of a judge as following the facts and the law where it leads, guided by the Constitution and by conviction and by political courage.
All right, this question goes to Justice French. What is the most important part of the job that you look forward to? Have you ever had to rule in a way that made you feel uncomfortable because the ruling was different than how you felt personally?
Well, thanks for that question. I think as a judge, if you're going to be a judge, you really have to be comfortable with the idea that you're not always going to like the ruling that you have to reach. My job as a judge is to be an umpire. It's to call balls and strikes. It's not to bring my own personal biases into the cases in front of us. And that means that there are times when I may not like the result at all. And so whether it's interpreting a statute or looking to the facts of the facts that are presented to us, there are times when my heart breaks because of the tragedy that's in front of us. But the most important thing I can do is to apply the law as it should be applied, just to the facts that appear in front of us. And I think, though, there's really more to it, and there's really a duty on us. And the things that I'm most proud of as a judge and the things I look forward to are some of the things that I can do off the bench. I have a voice as a justice, and I have used that voice as a justice to improve access to the civil justice system in the state of Ohio, to make sure that those underserved populations get the legal services that they need. So I look forward to that the most. I love the job on the bench. I love our oral arguments in our beautiful courtroom, but I also love what I can do with my voice as a justice off the bench.
And Judge Bruner, same question to you. What's the most important part of the job that you look forward to? Have you ever had to rule in a way that made you feel uncomfortable because it was different from how you felt personally?
Thank you, Karen. Because I've been an attorney for 37 years, I fully have embraced the idea that those who are officers of the court are really problem solvers. We help people, and that is the crux of our profession. We're specially trained to understand what rule of law means and to help interpret it and help people use it to solve their problems peaceably. I've served overseas as a rule of law expert in 2012, 2013, 2014, and 2015 in Serbia, in Egypt, in Sri Lanka. And being able to stand back from afar and look at what justice is all about, what corruption can do to hurt people's perception and confidence in the judiciary, taught me so much when I was able to then to use that here back in the United States in Ohio as a judge of the 10th District Court of Appeals. Yes, I've had to rule in ways that I don't relish and that I don't appreciate. And a lot of people think that a judge would be maybe 50% would like it and 50% wouldn't. And I would say that more likely, maybe only 30% would be actually happy with the outcome. But the key is that they trust the process. They feel that it was fair. And if that's the case, because they and we believe in the rule of law, our system of democracy works. Having run elections and the judiciary and been in the judiciary, those two pillars are key to a great and thriving democracy.
Judge Bruner, thank you. This next question goes to both of our challengers, and we'll begin with you, Judge O'Donnell. We have talked about the clean campaign pledge that the two incumbent justices have signed, but you have not. This raises the idea of money in campaigns, and the amounts grow each political season. Why haven't you signed, and how do you see the interaction between campaign finance reform and the First Amendment?
You talk about the so-called clean campaign pledge. Remember, this is a request by an outside group that a judicial candidate essentially forfeit his or her right to decide what passes muster in terms of other people's advertising. Two things here. One, I don't believe I have to worry about other people's advertising. Typically, these social welfare organizations that were empowered by the 2010 decision in Citizens United, typically, not always, but typically, they support candidates from a different side of the political perspective. The second thing, I'm a judge and I'm running to be a justice of the Ohio Supreme Court. To do so, I have to be confident in my judgment. So I will exercise my own judgment and denounce, if I see fit, some third-party advertising that might hypothetically appear. So I'm not going to abdicate my own personal judgment when I'm running because I believe I have good judgment. On the subject of money in campaigns, I mentioned the Citizens United decision. That has merely accelerated the problem of money in political campaigns. And of course, in judicial campaigns, there's even a separate level of difficulty with having them financed because of the impartiality of a judge.
Judge O'Donnell, thank you. Judge Bruner, same question to you, and I'll repeat it. We have talked about the clean campaign pledge that the two incumbent justices have signed, but you have not. It raises the idea of money in campaigns, and the amounts grow each political season. Why haven't you signed, and how do you see the interaction between campaign finance reform and First Amendment rights?
Thank you, Curtis. When I received the request from the Ohio State Bar Association, I thought long and hard about the request that they were asking me, that the request they presented to me, which was essentially to cede my independent thinking as a judge, along with my promise, my duty to abide by the Code of Judicial Conduct, and to let them decide for me which ads were objectionable. I will certainly call out ads that are objectionable, and I certainly have great respect for the members of the committee of the Bar Association. But I have pledged to be fiercely independent, and I think that's what the voters of Ohio want. And so it also called into play the integrity of the self-governance of the Ohio Supreme Court, as if to say that this group of lawyers could decide better than the Supreme Court could how the Code of Judicial Conduct should apply. And in terms of money and campaigns, again, there will be independent expenditures that none of the four of us can control. And when they're outrageous and when they harm the integrity of the judiciary, any one of us, I anticipate, will speak out whether or not we've signed that pledge. But as I see it, I believe the voters want a judge who, from the get-go, from the campaign all the way to the Supreme Court, will be independent and follow the law and have the welfare of the people in following that law in mind first and foremost, and not the judgment of a committee.
Thank you, Judge Bruner. Our next question goes to the two incumbents, and we'll begin with Justice French. U.S. Chief Justice John Roberts and Ohio Chief Justice Maureen O'Connor have both made recent powerful statements about how judges base their decision on the law, not on partisanship or personal beliefs. You are not running in a partisan race here, but there are partisan groups, such as the Ohio Business Roundtable, led by Republican former Congressman Pat Tiberi, suggesting that CEOs send out emails tying their job stability to a stable Supreme Court. But you have spoken at partisan events, even though you're not running in a partisan race here. Is that appropriate for you to do as a sitting justice, given the perception it can create?
Well, the quick answer is yes, it is appropriate for me to speak at partisan events. But in those events and in every other remark, all the other remarks I give, what I always explain is that judges and justices do not represent a political party. And as for the Business Roundtable and the CEOs that are encouraging their employees to vote for me, I applaud that effort. I believe that that is a correct statement that having me remain on the Ohio Supreme Court is better for the stability of the court. It's better for consistency and predictability. And I think that message really goes to the importance of following the law, of being someone who is not an activist, someone who exercises judicial restraint and doesn't take the law into our own hands. As a lawyer representing clients, that is certainly what I wanted in an Ohio Supreme Court, is one that was consistent and stable and predictable and followed its own precedent. If we don't have that, then we've got an activist majority that takes the law into its own hands. So I represent no political party. I make no pledges to come to any specific conclusions, but I do pledge to apply and follow the law in every case that comes before me, and to be a careful umpire calling balls and strikes.
Thank you, Justice French. Justice Kennedy, same question to you, and I'll repeat it. U.S. Chief Justice John Roberts and Ohio Chief Justice Maureen O'Connor have both made recent powerful statements about how justices and judges base their decisions on the law, not on partisanship or personal beliefs. There are partisan groups, though, such as the Ohio Business Roundtable, led by Republican former Congressman Pat Tiberi, suggesting that CEOs send out emails to employees tying their jobs and their job stability to a stable Supreme Court. This is not a partisan race again, but you have spoken at partisan events. Is that appropriate for you to do as a sitting justice, given the perception it can create?
And the simple answer again is yes. I agree with what Chief Justice Roberts and Chief Justice Maureen O'Connor have said. We as judicial officers interpret the law based on the law itself, not partisan influence. And it's really central and key to our republic. But it really is the truth that there are individuals who are supporting myself or any of the other candidates. To speak at a partisan event does not mean that I'm speaking on behalf of a party platform. No. When I speak in those groups, I talk about the tripartite system of government and why the third branch, why the role of the judiciary is important in the republic, explaining why we are separate but co-equal branches and the importance and independence that the judiciary brings in that voice. But also as it relates to the stability and predictability of the law, I believe individuals follow judicial philosophy. Judicial restraint tends to be an important factor in many's view on what the law should be. They don't want the law swinging in a pendulum. Judicial restraint, honoring your limited role in government, upholding the law as it's written, not rewriting it or legislating from the bench, making sure that we respect prior precedent so that the law is stable and predictable for all Ohioans, and it applies equally to every Ohioan.
Justice Kennedy, thank you. Justice French, this next question is for you. With racial disparities having emerged throughout Ohio's justice system, especially with bail bonds, how would you see the Supreme Court's role as the statewide court administrator to address inequities in the bail system?
Well, first, let me say very clearly that racism has no place in Ohio. Racism certainly has no place in the Ohio judiciary. I am proud to have been part of some reforms that went to bail. You know, the whole purpose of our bail system is to make sure that that defendant who's been charged comes back. And we want to ensure that that the trial courts are using the least restrictive means to make sure that that individual comes back. But I think that there's more that we can do. I agree with the work of the Ohio Sentencing Commission that really has advocated for more data. Let's get a database of the sentencing that's taking place in Ohio, whether it's the criminal sentencing or the bail that's being given out. Let's create a uniform sentencing database. It's only once we have good information that we can see where those problems of inequality are. Right now, we have just anecdotal evidence, but we need better data. So we don't have a specific proposal in front of us at the Ohio Supreme Court now, but I wholeheartedly support the idea of implementing a database. And I look forward to being a part of implementing that, understanding where and what our problems are and resolving them. And it'll only be through that transparency that I think the public and the media would have greater confidence in our criminal justice system.
Justice French, thank you. Judge Bruner, same question to you. With racial disparities having emerged throughout Ohio's justice system, especially with bail bonds, how would you see or use the Supreme Court's role as the statewide court administrator to address inequities in the bail system?
Thank you, Curtis. The Supreme Court can play a gigantic role in this process. It is the body that governs not only the judiciary in the state of Ohio, but also sanctions lawyers for problems when they don't abide by the Code of Professional Conduct. So bail reform begins with understanding that someone who doesn't have money doesn't deserve to be in jail more than someone who does have money just because they can pay the bond to get it out. The bond and the bail has to be related to the crime and to the likelihood that the person will actually come back to stand trial for the crimes of which he or she is accused. In terms of racial justice, I agree with Justice French on the institution of a statewide database. When I served as Secretary of State, we created a statewide database about the quality of life in Ohio using indicators that we focus group throughout the state. If you want to manage it, you have to measure it. If you want to measure it, you have to define it. So first we have to get to the data, and it may be a painful process for some, but that transparency starts to improve public confidence in this, and it also allows us to see what exactly the problems are that we have to deal with, and we can use collaborative, creative solutions involving not just the criminal justice system, but people outside it to help us ameliorate these problems so we can work toward ending racism in the criminal justice system, and I am committed to that.
Thank you, Judge Bruner. Switching races and topics now. This question is for Judge O'Donnell and Judge Kennedy. Judge O'Donnell, we'll start with you. All of you have raised at least $500,000 in this campaign. How do you avoid the perception that raising money and accepting campaign donations affects how you rule?
Well, if people perceive that that's what they perceive, there is little control that I have over that. I will have to say, though, that I don't assume a donor has a particular agenda. I assume, and perhaps I'm wrong, perhaps I'm naive, that a donor wants good government. Or in this event, a donor sees the record on the other side and thinks that I'm the candidate worth supporting. But here's a cliche. Money is a necessary evil. Ohio has about 8 million registered voters. It is impossible to reach those voters and try to persuade them that you're the better candidate without mass communication, which of course costs money. So I make no apologies for raising money. I wish that I could raise the $1.3 million or so that my opponent did, but nevertheless, I have people from all over Ohio, working people, lawyers, others supporting this campaign. My corporate contributions have been minimal. My contributions from insurance companies have been non-existent, but I suspect in the end, I will raise enough to get the message out that I am the candidate that the people of Ohio should prefer in this particular race.
Thank you, Judge O'Donnell. Justice Kennedy, same question to you, and I'll repeat it. All of you have raised at least $500,000 in this campaign this year. How do you avoid the perception that raising money and accepting campaign donations affects how you rule?
Well, thank you for the question. I realize the research that has gone on across America and that individuals believe that when a judicial candidate receives a contribution that somehow that influences an outcome in a case. And really the case that really everyone talks about is Caperton versus Massey Cole. But that was an enigma. That West Virginia case, Ohio is so restrictive. It is a necessary evil. As long as we are going to have judicial elections, we are going to be raising money to actually put forth our candidacy and our First Amendment voice and explaining to the voters why you are the better candidate. But when you look at Ohio, particularly, I think about explaining, as I do to many citizens, think about our window. We have a very narrow window of when judges and justices can raise money. It's only in the year of election. We have set limits. We do not permit corporate donations, and LLCs, law firms, are limited to a certain amount, just like individuals. And as a result of that, you also then have transparency. Because of the filing requirements, everyone can log on to the Secretary of State's office and see exactly where people are raising money. But in the end, money follows philosophy, judicial restraint, the stability and predictability of the law. That is what I believe that contributors see in me and why they're supporting me.
Justice Kennedy, thank you. A reminder to our viewers, this is the Ohio Supreme Court Judicial Candidates Forum 2020, presented by the Ohio Debate Commission. Thank you for spending this hour with us. Karen?
Let's go back to the questions. Again, switching races and topics. This question is for Judge Bruner and Justice French. We'll start with you, Judge Bruner. It comes in light of all we've learned about the COVID-19 pandemic. With evictions rising and societal disparities in broadband access, what policies would you enact to make sure that everyone is treated equally in virtual courtrooms? And how or would you suggest criminal sentences be adjusted for the safety of those who are convicted?
Thank you. Serving on the 10th District Court of Appeals, we immediately went to teleworking when the governor had the stay-in-place order. Personally, I prepared the protocol for our court on how to circulate decisions similar to how we've been circulating them before. We moved gradually to audio hearings, and then we played those live on Facebook, on YouTube, so that the public could follow those hearings, and then we moved to video hearings. Now that we've returned to in-person hearings in the courtroom, anyone who would be more comfortable with a video hearing still gets that hearing, and we still broadcast this on YouTube. With the trial court proceedings, I am aware that some courtrooms have managed to have counsel in different places, and the judge in the courtroom. The increased use of video, the increased use of broadband, and the increased access to broadband, especially in the rural areas, will be key to providing this for the future. We don't know how long the pandemic is going to go on. We don't know when we're going to be able to return to life as we thought was normal. But in the meantime, the courts must go on and must serve the public. So it's essential, and the Supreme Court has done a great job providing money for the local courts, but we must be adaptive, and we must allow at the same time access to justice. And this will be an ongoing issue for the next year or two, and will probably last on into the future.
Thank you, Judge Bruner. Justice French, same question to you, and I'll repeat it. In light of all we've learned from the COVID-19 pandemic, with evictions rising and societal disparities in broadband access, what policies would you enact to make sure everyone is treated equally in virtual courtrooms? And also, how or would you suggest criminal sentences be adjusted for the safety of those who are convicted?
Well, thank you for that question. I think when the Ohio judiciary looks back on the pandemic, we are going to see that it was one of our finest hours. All over the state, I am seeing creativity and innovation in dealing with the issues related to COVID-19 and making sure that we have fewer people in our courtrooms, but that justice is still served. So the judges of Ohio, for example, they're gathering jurors in community theaters or in performing arts centers. They're using technology in ways that they had never thought possible before, all in an effort to keep people away from the courthouses, but also to make our processes more efficient. I think we're going to see these technologies, they're going to be here to stay. I know I'm very proud of the fact that the Ohio Supreme Court already had cameras in our courtroom and already webcast out our arguments. And so we were able to seamlessly go to more virtual technology. But I think what we have found in the judiciary is some of these technologies make the justice system less expensive and more efficient for a lot of people. But you've raised the issue of criminal sentencing. I know trial courts around the state are addressing those criminal sentencings and sending fewer people into our prison system. And I think we do also have to address those underserved populations that may not have the technology that they need.
Justice French, thank you. This next question, Justice Kennedy, is for you. Once again, there's a push to overhaul the state's public school funding formula, which the court has ruled unconstitutional 4 times. What is the court's role and duty if it issues a decision compelling action by another branch of government, but that branch does not comply?
Well, thank you for the question. It is the #1 question I am asked across Ohio, regardless of where I am and what forum I am in. The DeRolf decision that declared school funding unconstitutional is a thorn in Ohioans' side. As I have the conversation with them, I talk to them about what is the role of the court. At the time in deciding the DeRolf case, it was placed before the court to decide whether or not the funding scheme was constitutional. The court having declared it unconstitutional, the law went back to the General Assembly, and there's where it lies. To me, it is the providence of the General Assembly to start again and write the law. It is not the province of the Supreme Court, and here's why. Think about how we do our work. In the legislative branch, they have the ability to set hearings, to have proponents and opponents come and testify. They have the ability to take in information and then write a law with everyone's input. Think about what we do as a justice at the Supreme Court. I have 2 parties, 2 briefs, and 7 of us contemplating the law. Ours is not the place where the law gets made. It goes back to the separation of powers and the founding. We are the voice of independent justice to declare a law unconstitutional, but it's up to the General Assembly to rewrite the laws. Thank you.
Justice Kennedy, thank you. Judge O'Donnell, same question to you. Once again, there's a push to overhaul the state's public school funding formula, which the court has ruled unconstitutional 4 times. What is the court's role and duty if it issues a decision compelling action by another branch of government, but that branch does not comply?
Well, first of all, I should say at this point that DeRolf is dead. And I'm not referring to the plaintiff DeRolf. I hope he or she is hale and hearty. But the decision itself in 2003, the court essentially told the trial court it couldn't exercise jurisdiction. And by then, the Supreme Court had already essentially said it had done its job. But so DeRolf itself is not going to be revived. But the school funding formula hasn't much changed since then. So it is possible the same issue could come up in a new case. It would have to come up through a trial court because there would need to be an evidentiary record. But suffice to say, the issues in DeRolf were decided in, I think, 20 or so different states who had similar cases. Some of those states, their Supreme Courts found a way to require the legislature to redo the law. So it's not impossible. And this brings me back to the terms judicial activism and its, judicial restraint and its evil twin, judicial activism. Let's be frank. These are shibboleths invoked for the initiated. And I got to say, thank God for my children who I mentioned at the start and for their Black and brown classmates in our integrated school district, because if it weren't for the judicial activism of 9 justices of the Ohio Supreme Court in 1954, we would still have separate and truly unequal systems of education in our country.
Thank you, Judge O'Donnell. Let's switch races and topics again. And this question is for Judge Bruner and Justice French. Judge Bruner, I'll start with you. All judges are required to base decisions on the law and the facts, but many times when voters seek to differentiate between candidates, especially in nonpartisan races, they do so based on life experiences and personal beliefs of those running. How do you keep the two separate when on the bench?
When on the bench, you have already taken as a judge an oath to follow the laws and the constitutions of the state and to abide by those laws. When I spoke earlier about the overseas work that I did and rule of law, I understand also the delicate balance between the 3 branches of government. It has always informed my judicial philosophy that separation of powers is paramount to a fully functioning government and a fully functioning democracy, and to a judiciary that does its part in that tripartite form of government. So you'll hear people say that they are conserving their power, and they equate that with staying in their lane. But I think what really needs to be looked at is there are times when the judiciary must fully occupy its lane and do its job to check the other branches of government. And that has to be done with great care, great caution, great thought. And in the case of a 7-member court, with a conference with all of those justices. That is what guides me. And even though I'm a person who's experienced a lot of and seen a lot of difficult things in life, what informs me the most is that what will work best is if I first and foremost follow that oath, knowing that in the end, it will preserve a system that is balanced and works well for the people I love so dearly in the state of Ohio. So this helps balance it. This is the process I use, and this is what I will continue to do.
Thank you, Judge Bruner. Now, same question to Justice French, and I'll repeat it. All judges are required to base decisions on the law and the facts, but many times when voters seek to differentiate between candidates, especially in nonpartisan situations, they do base so on life experiences and personal beliefs of those running. How do you keep the two separate when you're on the bench?
Well, thank you for that question. I think you're right that many voters do look at life experience, and I think it can help inform what kind of person that judge is or will be. Is this someone who is going to be efficient on the bench? Are they going to seek to clarify the law, to work hard, to have a good work ethic? But with every case that comes across my desk, whether it's a virtual one or I'm picking up a file, I begin with what the law is. You know, our process begins with someone asking us to take jurisdiction of a case. We get briefs, which I can tell you are not brief, that give us a thorough analysis of the issues in front of us. And then we have an oral argument that gives us a wonderful dialogue between the justices and the lawyers or the parties presenting the case. And then we go into conference with the other justices. And within all of that, I'm also talking over these cases with my own judicial attorneys over Taco Tuesday to really get to what is the right view of the law. Yes, judicial philosophy is critically important because it defines how I see my role on the bench. But in every case, we also have precedent and standards of review and all of those other guidelines that direct how we have address that specific case. So while my life experience keeps me efficient and working hard on the bench, it's the law that I have to seek out and apply in every case.
Justice French, thank you. Judge O'Donnell, Supreme Court justices have called for the end of mayor's courts, which have much lower professional standards than other courts. Should mayor's courts exist in Ohio?
I think that's a question for the legislatures. As I recall, those are created by legislation, and they would be abolished by legislation. In my own experience with mayor's courts, which is very limited, I have observed, I think, the problems you're talking about. They tend to be a little bit slapdash, and when you slapdash, you may wind up not doing justice. But I'm not going to tell the legislature it should or shouldn't eliminate mayor's courts. That is, speaking of staying in one's lane, that's for the political branch.
Justice Kennedy, the same question to you. Previous Supreme Court justices have called for the end of mayor's courts, which have much lower professional standards than other courts. Should mayor's courts exist in Ohio?
Well, thank you for the question, and it's a great one. When I speak to civic organizations or students and really talk about the judicial system, it gives me the opportunity to lay out the trial court system, the appellate system, and the Supreme Court. But I always start with a conversation about mayor's courts because they do exist. As I say to the students and civic organizations, they are not courts of record. So it's really important to understand the limited role they have. A mayor's court has the ability to preside over those cases that are related to a violation of a city ordinance. They do not have the power to impose a sanction of incarceration or a term in jail. They really only have the ability to decide whether or not the law was violated and then set a fine. Many citizens believe that this is what gives way to the speed traps. To me, I think there's been a movement in mayor's courts to bring professionalism to the bench while they're hiring lawyers and others to serve in that capacity, where mayors themselves who are not educated in the law aren't sitting there anymore. As that goes forward, though, it's really up to the General Assembly. They have the power to create courts, and they have the power to take them away. Thank you.
Thank you, Justice Kennedy. Again, switching races and topics here, and we'll go to Justice French and Judge Bruner for this. And we'll start with Justice French. We see wildly different treatment, fines, fees, and sentences for misdemeanor offenses in different Ohio municipal courts. Does the Ohio Supreme Court have a responsibility to bring equity and fair treatment across the state's municipal court landscape?
Absolutely. I think that we do. I think it's our responsibility. We don't have supervisory control over the courts of Ohio, but I think we have a role to play in ensuring equity. There is one troubling message that I hear around the state, and that is that there is inequity in the court systems, whether that is a racial inequity or monetary inequity or inequity based on where you are. And so I think that it is somewhat important for us to at least be aware of what we are dealing with and the inequities that are out there. I think that something like the sentencing database would help bring confidence, because we would have greater transparency about what is being given out in these courts around Ohio. I think it's important to recognize, though, again, that we do not have supervisory control, that these judges are elected in your individual communities. They are elected to serve you, and they are beholden to the voters in that community. So I think while I think it's important for the Ohio Supreme Court to identify what is happening and see if there is a great disparity, we also have to consider that it's the legislature's role to define sentences to some extent. So again, we have a more limited role, but one that I think we could use to at least identify any problems that we have.
Thank you, Justice French. Now let's turn to Judge Bruner with the same question, and I'll repeat it. We see wildly different treatment, fines, fees, and sentences for misdemeanor offenses in different Ohio municipal courts. Does the Ohio Supreme Court have a responsibility to bring equity and fair treatment across the state's municipal court landscape?
Thank you, Karen. So Ohio is traditionally a strong home rule state. Sometimes decisions of the Supreme Court may undermine that, depending upon how the Constitution is interpreted. But Ohio clearly is not the wild, wild west. The Supreme Court of Ohio does have a responsibility. It has the responsibility for leadership. And again, it is in the best position to increase the public's confidence in its judiciary. There are rules that govern the operation of the courts of Ohio. There are rules for the governance of the courts of Ohio. The Supreme Court has traditionally been collaborative with the local courts, and that's a very good thing, because any kind of change needs to be actually embraced by those courts so that it's adopted and implemented in a fair and orderly way. So yes, it's a problem that the court should identify, should bring people together on, and should have clear goals, because we owe this to the people. There's a reason why part of the way that I fashion my campaign is justice for the people, because again, the court will be stronger if the people who are served by that court feel confident about the court's activities. And the Ohio Supreme Court clearly can be a leader in making sure that people in localities around Ohio feel like they are being treated equally and fairly and being respected in the process of the judiciary doing its work. Thank you.
Judge Brunner, thank you. Judge O'Donnell, this next question is for you, sir. What do you see as the court's role in refereeing disputes between the other two branches of government, the legislative and the executive?
Well, first things first, I want to say to Justice French, if you heard me exclaiming during your last answer, I was trying to adjust a bulky camera stand. So I apologize for muttering a little bit while you were answering. It's possible you might have heard me. That role I alluded to earlier. Since 1803, judicial review has been the law of the land. By the way, judicial review is not written into the Constitution. It was inferred by Chief Justice John Marshall from the structure and, of course, the language of the Constitution. Again, that sounds to me like a term that's never really been defined, but I believe some people would call it judicial activism. Well, thank God for that. Otherwise, our three-legged stool, executive, legislative, judicial, would be a two-legged stool, and it wouldn't stand. So the judiciary has no business telling the legislature what law it should make. The judiciary has little business telling the executive how to enforce those laws. But the judiciary must, when one or both of those branches exceeds its constitutional bounds, step in. If we don't, we're not doing our job.
Judge O'Donnell, thank you. Justice Kennedy, the same question to you. What do you see as the court's role in refereeing disputes between the two other branches of government, the legislative and the executive?
Well, thank you for the question. It really depends on what the controversy is, because as you appreciate the independent but co-equal branches of government, the legislative branch enacts the law, the executive branch goes forth, gives it effect, and enforces it. And the judicial branch waits for the controversies to come. We interpret the law as it's written, not rewrite it or legislate from the bench. So the first issue you have to have is it a justiciable event? Is there something that has happened between the two branches to which a cause of action can be filed? And then where does it go? The question then becomes, is that something that begins at a trial court? Is that something that they can use one of the great writs and to bring it into the Supreme Court itself? That justiciable controversy oftentimes begins at a trial court, whatever the issue is that they have a dispute over. As the trial court rules upon it, it may go to the appellate court and then on appellate review to our court. But that really begins the case and controversy. What is the case? What is the controversy? And is it justiciable? Can they bring it directly to the Supreme Court as a great writ action? If not, it begins in the trial courts.
Your Honors, thank you. That concludes the question and answer portion of this program. Each candidate will now have 60 seconds for a closing statement. We begin where we started with Justice Kennedy.
Well, good evening, and thank you to the viewers, the moderators, and the Ohio Debate Commission for this great opportunity. To the young viewers today, let me just say, I never imagined I would be a justice of the Supreme Court of Ohio. In my life, I saw such limitations based on socioeconomics. But the reality is that if you can dream it, you can become it. Find great mentors in your life and stretch beyond the barriers and the ceilings you see for yourself. To the voters of Ohio, thank you for entrusting me with this great honor to serve you and all Ohioans as a justice in 2012 and 14. I ask you for your vote this year so I can continue my work, so I can use my diverse experience to bring forth independent, judicial rulings with clear, concise, and to help those achieve a life holistically, like our veterans, the returning reentry, and others. Thank you.
Justice Kennedy, thank you. Judge O'Donnell, you now have 60 seconds for your closing statement.
So, to my fellow Ohioans, you need to know that the Ohio Supreme Court matters. Day after day, week after week, it makes decisions that affect your lives, sometimes a little bit, sometimes a lot. You need justices on the Ohio Supreme Court who are independent and who have the fortitude to follow the law where it leads. Where it leads. You know who else wants good government in the state of Ohio? And I know that in certain political quarters, news organizations are considered anathema. But in this election, two of the major newspapers that are still left in Ohio, in Cleveland and Columbus, have endorsed my election over an eight-year incumbent. That almost never happens, but it happened this year because those organizations want good government just like you. I'm asking for your vote for the Ohio Supreme Court.
Thank you, Judge O'Donnell. Justice French, you have 60 seconds for your closing statement.
Well, thank you. Thank you to the Ohio Debate Commission and to all of you watching for recognizing the importance of the Ohio Supreme Court. I've served as a justice on the court now for nearly 8 years. I'm proud of the work that I've done on the bench. I've shown that I am a careful umpire when it comes to resolving disputes, but also that I care about clarity and efficiency. I'm also proud of the work that I've done off the bench. I've traveled to all 88 counties many times, all in an effort to get to know Ohio better and get to know the impact of the Ohio judiciary. I've been a part of important reforms to expand access to the justice system. But there is more work to do. I think we have a judiciary to be proud of in the state of Ohio, but I look forward to being a part of making it better. My name is Judy French, and I ask for your vote for re-election to the Ohio Supreme Court. Thank you.
Justice French, thank you. Judge Bruner, you have 60 seconds for your closing statement.
Thank you. Thank you to the Ohio Debate Commission, and thank you to those of you who are viewing this. When I was awarded the John F. Kennedy Profile and Courage Award by the bipartisan board of the Kennedy Library in 2008, when I served as Secretary of State, I had to prepare remarks and I had to think about what my views and my devotion to public service was all about. And it boils down to this: fairness, equality, and respect. Those are values that I can carry into the Ohio Supreme Court as a justice. I view myself as a public servant who happens to be a judge and who, in doing that, keeps the rule of law first and foremost because I understand what it means to the quality of life for people in the state of Ohio. If you have a strong quality of life in Ohio based on the rule of law, you have stability, you have predictability, you have safety, and when done very, very well, you have a springboard for pursuing your happiness and following your dreams. I will do this for as long as I can, and I thank you very much for your consideration.
Thank you to our Ohio Supreme Court judicial candidates, Judge Jennifer Bruner of the 10th District Court of Appeals, Justice Judy French of the Ohio Supreme Court, Justice Sharon L. Kennedy of the Ohio Supreme Court, and Judge John P. O'Donnell, Cuyahoga County Court of Common Pleas. Thank you all for participating tonight.
This wraps up the Ohio Supreme Court Judicial Candidates Forum 2020, brought to you by the Ohio Debate Commission. I'm Karen Kassler. On behalf of my colleague, Curtis Jackson of Spectrum News, we hope this forum will make you a more informed voter as you cast your ballot this election season.